Hello, ladies and gentlemen. I'm Paul Butt. I'd like to say a few words about one of the lectures I deliver for the Solicitors Group. And the particular one I want to talk about today is co-ownership. Now, of course, co-ownership is something that, as conveyancers, we deal with every day. I think it's fair to say that most properties being purchased, most residential properties, are owned jointly, husband and wife, cohabitees, whatever it might be. But we do need to make sure that when we're acting for such purchasers, that the advice we give them as to the type of co-ownership they're going to enter into is fully up to date and compliant with best practice. The advice we give as to whether they're going to be joint tenants or tenants in common, and if tenants in common, in what shares they're going to own the property. Regrettably, residential conveyancing is the biggest single area as far as negligence claims are concerned. According to the SRA, somewhat approaching 50% by value of all negligence claims are brought in relation to residential conveyancing. And a goodly number of those are brought in relation to the advice we give to co-owners on the purchase of the property. Indeed, you may have seen fairly recently, a few weeks ago, extensive press coverage of an action brought by Geoffrey Boycott, the ex-England cricketer, against his ex-solicitors in relation to property he purchased some years ago with his ex-partner. And he was claiming that he hadn't been properly advised, that he didn't realise that if he bought the property as joint tenants with the young lady, that she could then sever that joint tenancy and she'd end up owning a 50% share. The allegation was he hadn't been properly advised. Now, precisely what advice he was given, we don't want to go into, but the fact is he brought the claim in the first place. Are your systems and procedures sufficient to enable you to resist any similar claim? On the facts of the case, he lost, based on the fact that his action was brought outside the limitation period. As I say, there was never any proof that he did actually have a valid cause of action. So, it is an area that we do need to be very careful in advising on. Obviously, the first thing we need to be aware of is that, according to the Law Sales Conveyancing Handbook, the advice that we give should be in language appropriate to the level of understanding of the client. It's perhaps fair to say that you can never underestimate the level of understanding of many clients. So we do need to get away from the traditional situation of talking about joint tenants and tenants in common. What on earth does this mean to the average person? This is what Jeff Boycott was saying, all this legal jargon, how was he supposed to understand it, assuming that that was the advice that he was given. We've got to give this advice in plain, simple English. If not, well, we're on a hiding to nothing, we're on the back foot right from the start. Equally, what the Law Study Conveyancing Handbook says is that we must advise as to what form of co-ownership is appropriate in the particular circumstances of the case. It isn't just sufficient to say, well, this is what a joint tenancy entails, this is a tenancy in common, which do you want? We are supposedly advising on what is best in the particular situation. And of course, the difficulty is how do we do that in the context of an ordinary residential conveyancing transaction where we are perhaps never see the client, where we are under the constraints of the fee that we are charging, which will not be very much. This is something that I will be going into in the lecture. Obviously, we do need a printed handout, a information sheet, call it what you will, explaining things to the clients in plain, simple language. And we do need to make sure this is compliant with best practice. Equally, of course, we have to bear in mind the question of conflicts of interest. It may well be that if one of the potential co-owners is putting all the money into the property, that from his or her point of view, being joint tenants isn't advisable. Obviously, from the views of the recipient, who will, on a severance, be entitled to a full 50% share of that property. From their point of view, it probably is. So we do need to be careful about conflicts of interest. We do need to take steps to cover that possibility that there is a conflict. So there are lots of issues involved, lots of information we need to give to clients. But the Jeff Boycott case does show the biggest single problem. People enter into these transactions, they buy as joint tenants, they don't appreciate that on a severance it will be 50-50, irrespective of the shares that were put in, irrespective of how they contributed to the payments. 50-50 is what the end result will be because of that joint tenancy. So basically, it is a worrying area, an area that we need to take lots of care with. We've got to consider the advice in the Law Society Conveyancing Handbook, need to make sure we comply with it, but above all we need to make sure that we can prove the advice that we've given. It's not just sufficient to give the advice. Should things go wrong years down the line, we do have to be in a position where we can positively prove that we gave this advice to these particular clients. So everything has got to be in writing. We've got to get the clients to sign something to say that they received the advice, that they understood it, and that they decided to go ahead in this particular way. At the end of the day, it's about protecting ourselves as well as protecting the clients. Anyway, that's just a flavour of the kind of thing I will be talking about. I do hope that we will see you soon on a conference organised by the Solicitors Group. Anyway, thank you for listening.